Damien Reel, and I think we're going to get started because I have a lot of information that I want to present to you. This is going to be a tech smorgasbord. There's going to be a ton of cases here. There's going to be a ton of law. If you're not going to write any of this down because I have written materials. If you want them, go ahead and hit me up on Damien Reel at Twitter, and I'll give you the written materials. We're largely going to be doing a rapid-fire presentation. If you don't like what you hear, wait a minute and a half, and it's going to change. So the first thing we're going to talk about is autonomous vehicles, something that's near and dear to my heart. This is, as anyone who's been following the space here today, just not here, it's not distributed. Sometimes it looks like this. Sometimes it looks like that as Uber's incarnation. But really, if all is horrible in the world, it's going to look like that. So that's Google's iteration of what the self-driving car will be. And for some reason, my clicker is not working, so I'll do this. So a lot of companies are in this space. Any company who's making cars is thinking about how they're going to have autonomous vehicles. So that, of course, is shaking up the legal space as well. So this is, if you believe Elon Musk, you believe that what they have at Tesla and presumably at Google and Uber and whoever's building these things blows his mind. And if Elon Musk's mind is blown, then my mind is going to be blown as well. The idea of autonomous vehicles is there are 5 different levels of autonomy. 0 is manual, like we have today. 5 is full automation, where it may not have a steering wheel or brakes or anything like that. So today we're really at 0 through 3. So the most advanced that are out on the road today are 3. But of course, they're testing all the way to 5. So the way they have the way they work is through LiDAR. So you have LiDAR going around trying to simulate what is out in the world, as you can see in the top there. And then this is another demonstration of what the computer sees when Google's machines are going around. So if Elon Musk has his way and everyone else has his way, by 2018, you're going to be to full 5. And there's a question as to whether we should even settle for 1 through 4 or whether we should jump straight to 5, because really the most harmful part of a vehicle today is the meat in the seat, as they say, the people that are texting, drinking, driving, et cetera. So if Elon Musk has his way, 2018, we're going to be have a driverless future, at least an incarnation of the driverless future. So what do the feds do? Right? What do the federal regulators do? And what they've said largely is go ahead and do it. Put it out in the roads. This is going to save a ton of lives. So you should put it out in the roads, and we'll regulate in the back end. So they see this as a safety device, because most of the accidents today are through driver error. So if you get rid of the driver, you make the road safer. And they're saying just like the safety belt, just like the airbags, we're going to let them deploy them in the field, and then we'll figure out what the problems are, and then we'll regulate on the back end. But go ahead, we're not going to wait for people to die to be able to figure this out. Let's get it out on the roads as soon as possible. So they, in September, gave a bunch of guidance saying pretty much full speed ahead for all of you autonomous vehicle owners or creators. Go ahead and we're going to show you how to perform. We're going to have model policies, model regulations, model laws for states to follow. And they're going to clarify the existing federal rules, pretty much paving the way, pun very much intended, paving the way for all of the autonomous vehicles. And they said that this self-driving car could be the greatest revolution in transportation in the history. So they're largely saying, just go ahead and do it, and we'll follow up behind you. Elon Musk, again, if he has his way, he said this in 2016. He said, I think within 2 years, you're going to be able to be in LA, say to your New York car, go ahead and come to LA, and it'll drive itself from New York to LA. That's Elon Musk. He's certainly a dreamer, but if he believes something, I tend to believe it. But for that car to make its way from New York to LA, of course, you have to go through a lot of states. And there's real questions as to whether the states will regulate it and whether they'll prohibit it. But really, thus far, any states that have actually hit the topic of autonomous vehicles have been in favor of it. So these are the states that have talked about autonomous vehicles and what can be done. Largely, of course, California makes sense because that's where a lot of the Silicon Valley work is being done. Of course, Nevada, wide open spaces close to California, so that totally makes sense. Michigan, of course, that's where car makers are, so they're doing a lot of work there. Florida, turns out Florida has a lot of old people, right? So it's a standard reason that, and one of the benefits of self-driving cars, of course, grandma or grandpa will be able to get around where they can't currently get around because they don't have the keys to the car. I talked about the biggest problem being the meat in the seat, the humans actually making a lot of accidents. So you can see here trend lines from 1975 on the left all the way to 2015 on the right. And the trend lines have largely been going down as far as traffic fatalities. But then you see the bump in 2015, and a lot of that bump is attributed to texting, right? Texting, distracted driving, et cetera. Here's another, AT&T did a study, and why AT&T did this study, I'm not sure, but they showed that a huge number of people are texting. 61% of people say that they text while they drive. They also say they email while they drive. A third of people do this, and those are people that admit to AT&T that they do such things. So you can imagine that people that don't admit it might be even larger. Here's in Minnesota, you have 3 types of factors that contribute to deaths. The one factor is human factors, second is vehicular factors, and the third is roadway factors like that. So this is data from Minnesota showing that human factors take up almost 50% of the most common causes. You can see driver inattention, failure to yield, and following too closely are 3 of the most common things. And so those are all human problems that potentially autonomous vehicles could solve. On the left, you see 1979. This is a Venn diagram of national federal studies showing what it was the causes of accidents. And so you can see driver is the most, roadway, and then vehicle. And of course, there's a combination of all 3. But you can see we've made our roadways safer, we've made our vehicles safer, but we have not made our humans safer. So as we make those environments and vehicles shrink, of course, the bigger part of the pie is drivers. And of course, that's this problem that technologists like autonomous vehicle creators want to solve. Here's another diagram showing what the critical reason, right? So of that Venn diagram, which was the most important? On the left is drivers, and environment and vehicles are just dwarfed in comparison. So this is what the feds are saying. Now look at these numbers. How can we fix this, right? Of course, technology, right? We get rid of the driver, we get rid of all these deaths. But then you might say, well, you know, what if people die? And so far, 1 person has died. There was a crash with the Tesla where the autonomous vehicle, the Tesla, thought that a tractor trailer, a truck, was a white truck was the sky. So it essentially went underneath the truck and killed the driver. But it turns out that, again, from that 1 through 5, it was a level 3 vehicle. And under a level 3, the driver needs to pay total attention. You still take over if necessary. But according to reports, he was watching a Harry Potter video while he was doing that. So there's been 1 death. Query whether it was actually the machine's fault or the human's fault for paying attention or not. But there's been 1 death and 130 million miles driven for autonomous vehicles. And that compares to about 1.38 deaths for humans, right? So even today, it's safer for the machine to drive than later. And of course, we have Moore's Law, and we're just at the infancy of autonomous vehicles. Query in 5, 10, 15 years how much safer we'll be with the machines rather than humans. So another thing that the feds said in 2016 is that every manufacturer of autonomous vehicles needs to share edge cases. So for that Tesla crash that I mentioned earlier, Tesla now has to share the underlying data, the precipitating data before the crash, with every other manufacturer, with Google, with Uber, with whomever is chasing this thing, so that will never happen again, right? So in that way, they're saying each of these edge cases can be shared with all autonomous vehicles, and in that way, they keep learning, right? And that'll never happen again. And query whether a 16-year-old that makes the same mistake over and over, every 16-year-old makes the same mistake as every other 16-year-old before they actually started driving. But presumably, every autonomous vehicle will not make the same mistake as every other autonomous vehicle because collectively, they'll learn from their mistakes. Everybody remember Maximum Overdrive, the Stephen King show, where all the trucks came over? I was thinking about that as we were thinking there's a lot of talk about robots taking over jobs, right? There's a lot of talk about robot lawyers, robot doctors, et cetera. Robot truckers is pretty close. If you look at the number of truck drivers, as far as the number of states that have truck driver as the most common occupation in that state, look at all that light blue. It's the most common everywhere. And according to the autonomous vehicle people, trucks, that's the easiest case scenario, right? You have long stretches of straight. You don't have traffic lights. You don't have pedestrians. You largely don't have animals, right? You just have long stretches of straight for hundreds and thousands of miles, right? And the difference, too, is that truck drivers are the most important and most expensive part of trucking. About 80% of the cost of moving things from point A to point B is the human cost. Also, truckers can only drive for 8 hours a day, right? So then they're sitting for two-thirds of the time. Compare that with robots, which can drive 24 hours a day. They're fixed costs. There's no such thing as unemployment rates, that sort of thing. You don't have to pay health care benefits to a robot. So there's actually a 400% performance to price increase because they can drive 24 hours a day. It's way cheaper to have a robot truck driver than it is a human truck driver. So that, everyone says, is the lowest hanging fruit that, of course, everybody's going to be saying, let's have robot truck drivers. So what will happen to all these people when it's 8.7 million people in the trucking industry, which is about 6% of the labor force. When they go away, you're not going to build a wall to be able to get rid of the robot drivers, because largely that's at the intersection of business, government, and tech. Right? The business is saying, listen, there's 400% performance price increase if I have a robot truck. Oh, of course I'm going to do that. The government's saying, oh yeah, of course. It's going to make the roads so much safer. You don't have the person driving instead of 8 hours, they're driving 16 hours and then nodding off, and then the semi plows into people. Of course, I want it to be safer, right? The government says. And no doubt the technologists are saying, yeah, let's do it, right? This is going to be a huge money-making opportunity. So at the intersection of that Venn diagram, you have robot drivers, which will query what's going to happen to that most common job description in all 50 states. All right, that was number one, autonomous vehicles. Number two, privacy. Everybody knows how the internet works, right? You go use a PC to go, use your ISP to go to the internet. And then based on that, there's a new, the FCC has proposed a regulation that says that all of the data that goes through the ISP, the financial data if you're banking, if you happen to be something that's untoward that you wouldn't want your grandmother to know, or any family data, if your child's surfing the internet, doing kids things. Under current regulations, or at least current non-regulations, the ISP could go ahead and package that up and then sell it to advertisers, to government entities, or to courts. Right? They could go ahead and soak that all up without you even saying yes or no. So instead, in 2016 of last year, October of last year, the FCC under Tom Wheeler, who was the Obama chairman of the FCC, said, you ISPs, before you can package up this data that's going through the pipes, you need to let your people opt in to collection of that data, not opt out. And only through then can you have the browsing history, app use, et cetera, and then pass it along to whoever advertises, et cetera. On March 23rd, 2 days ago, the Senate voted to actually strike that down. So, of course, the Senate trumps the FCC, the Congress trumps the FCC. So they say, no, ISPs can go totally share all that data, consumer data, and if it passes then the House and the executive, then of course it becomes law. So at any rate, what the October giveth, March taketh away. And so if you care about such things, you might want to talk to your representative to see if we can maybe change that for the future. What's going to happen? What else? Biometrics is a big part of privacy. We're hosting a Super Bowl. Apparently that's some pig flesh that you throw. I don't know, I have no idea. But apparently we're hosting it here. Part of the hosting it here is that biometrics is being experimented with the sheriff's office. So the sheriff's office is working with some tech to use on cameras going into there to be able to do biometric markers and see if you fit a profile of existing or known or wanted people. So it turns out that somebody sued saying, hey, we want to see all the data that's related to us using this thing, or at least thinking about using it. And the administrative law judge said, yeah, you have to actually turn over all this data relating to biometrics about what you're going to be actually using it for. Some of the quotes, the juicy quotes within the Hennepin County Sheriff's Office are, the system's so good that it found close relatives. And even if it's not an exact match with the person, it's a relative of that person. Of course, if we find that person's cousin, we might be able to find that person. And even though it costs a shit ton, they said, I still love it. Courts around the country have talked about whether you can use biometrics fingers, whether you can compel somebody to put their finger on their phone to be able to unlock their phone to be able to get to the underlying data. The courts almost uniformly have said, yeah, you can compel somebody, you can make somebody use the fingerprint reader and then be able to open up the phone, and then the feds or the state authorities would have access to it. That's okay, because that's largely the same as you giving a strand of your hair or giving a handwriting sample or an actual key. That's not actually requiring a Fifth Amendment privilege, right? Under the Fifth Amendment, you can't incriminate yourself. But this is not incriminating myself, where if I were to be required to have my password, right? If I were to say my password is XYZ, that is my vocal Fifth Amendment, and the courts have largely said, no, you can't require them to give a password, even though you can require them to give a fingerprint. So word to the wise, I know none of you are going to be arrested or otherwise, but it might be wise if you have the fingerprint enabled, if you're thinking about getting arrested, which I know all of us are, you might want to shut off your phone, right, and then let it shut down, and then when you boot up, often it will require the numeric code, which will not be compelled to be given up where you can be given up the fingerprints. This happened in February of last year with a woman in California. She pleaded no contest. They wanted the fingerprint, so the judge said, you have a warrant to get the fingerprint within 45 minutes, and then they had her fingerprint. So this can be done very, very quickly. Another frightening aspect, technologists are so awesome, right? The cops said, hey, you technologists who are, I think in Michigan, they said, yeah, Michigan State University, they said, can you replicate a fingerprint for us? Because this guy's dead. And they said, oh yeah, I think we could do that. So they used conductive paper and they printed flesh-like things through conductive paper and then put it on their, this fake fingerprint on the real finger, and then actually they were able to unlock the phone. So this is for somebody who was a victim of a crime. So this wasn't a case where they had tried to find something for a criminal, but query whether you could take a dead alleged perpetrators or some other one and fake their fingerprint. That raises some thorny legal issues. Illinois is one of the only states in the country that has a Biometric Information Privacy Act, saying largely you have a right to be able to protect your biometric data. So because of this, a lot of private individuals have done class action lawsuits against people that are collecting biometric data like Facebook, Google, Shutterfly, Snapchat, et cetera. Of course, Facebook, anyone who's done it says, hey, is this Joe Smith? Because this looks like Joe Smith. Of course, what they're doing is going through all the biometric data and knowing what Joe Smith looks like based on how far their eyes are apart and how far the lips are. And a lot of people are alleging that representing the class of pretty much everybody who has a Facebook account, that's violating the Illinois statute. So there's lots of litigation on that. That's not yet been worked out. Turns out the FBI and NIST are working to be able to figure out tattoos based on biometric. Then, you know, is a tattoo a biometric marker? I suppose it might be, right? I mean, if a scar is a biometric marker, maybe a tattoo is too. But it turns out that they're trying to find that as well. Cloud data requests. Microsoft, as you can imagine, and all the cloud providers get a lot of requests for cloud data. And so they fought back, Microsoft has. And Microsoft, I've always seen them as the monster at Redmond that is doing horrible things. And then I felt them like a little sad puppy dog that was getting rolled over the last 7 years or so. And now they're actually coming back and they're doing cool things. One of the things is fighting government request, saying that we shouldn't have to disclose all of these things. And it turns out that they're winning pretty often. They say that the court said that people don't give up their rights when they move from physical to the cloud, right? So if I have a safe full of documents, I don't give up my rights without a warrant. And similarly, if I have a cloud full of documents, right, I don't give up my rights. And so the government has exploited the transition to the cloud, saying even though we can't get it in the safe, we get it in the cloud. Microsoft's saying no, that's not right. So they're fighting the good fight. Strangely, the amicus brief, this is a brief of friends of the court saying, hey, we agree with Microsoft. Fox News and the Washington Post are both agreeing with each other on something. Totally bizarre. Along with the Electronic Freedom Foundation, I don't think that the EFF has ever agreed with the Fox News. But all the tech giants, Delta, et cetera, they all signed on to this thing saying what the government's trying to do by reaching into the data, into the cloud where they couldn't in a physical space, that's wrong. Microsoft has fought again. This last one was in the West Coast. This one's on the East Coast in the Second Circuit, saying that they had a governmental request saying, you know, all that data that you have on Irish servers, you should go ahead and hand that over. And the court and the Microsoft is saying, hey, no, those are outside of our borders, right? That would have a really bad precedent if a U.S. court could say go anywhere in the world and pull in all sorts of data, right? Imagine if North Korea were to say, you know, you have to, or China is probably a better example. China, you have to go and search all of your US servers. China would say that to Microsoft. That would be a bad precedent. So in the same way, Microsoft's saying, hey, why should I, in the US, have to search UK servers, right? Or Irish servers. So they're fighting the good fight there as well. And the court agreed with them there. Private company assistance, everybody heard about the February 2016 debacle and San Bernardino shooters. You know, they're both dead. We need to get to the phone. How do we get into it? Well, how about we compel Apple to write code to be able to break their encryption to make everybody unsafe? That was essentially what they're saying. And the court said, yep, Apple, you're going to have to do that. The All Writs Act applies, which is essentially the All Writs Act is saying that you can compel somebody to do something for a governmental purpose. So you can compel Apple to do that for a governmental purpose. But then after, of course, some posturing, they just got a hacking group to do it, and so they didn't force Apple to do it. What was less commonly publicized, and in March 2016, they made the same argument in New York, And a court said the All Writs Act was inapplicable, that you cannot force a corporation, a software developer, to essentially make their software weaker by breaking encryption. It's going to happen. Who knows? Of course, that's how our law is. You know, one court decides one way, another court decides another way. Hopefully, a higher court will be able to settle it. And the FBI, in the meanwhile, says, all right, come on, let's have an adult conversation about this. There's bad guys out there, and we need to get to them. And with encryption, we can't get to them. So what do? Let's have an adult conversation, is essentially what they're saying. Speaking of adult conversations, Stingray. Anybody heard of Stingray, the idea? Yeah, lots of people. So I'm not going to explain too much how it is, other than they're fake cell towers that you feed through the data through the Stingray device. Then people can eavesdrop and then push the data to the end user without them necessarily knowing that they've been eavesdropped upon. So for the first time, evidence obtained from Stingray has been suppressed in court. So essentially, the police got evidence, brought it to the court, and the court said, no, I'm not going to consider it, and you can't show it to the jury because it was not lawfully obtained. They said that it was not done through a warrant. The court didn't sign off on it. So that was a Fourth Amendment violation. It's an unlawful search and seizure, so we're not going to use it in front of the jury. So that was in July of 2016. A big problem with privacy lawsuits, so if you sue somebody for breaching your privacy, say there's a data breach, right, and then I have all my personally identifiable information along with 7 million or 700 million of my closest friends, they all get stolen. Can I have a class action against the company that got hacked because they were negligent in their security? For a long time, people have said that you can't sue because I can't prove, as one of 7 million, that even though it's been hacked, I can't prove that my information's been used out there, right? I can't prove that somebody used my address to be able to cross-correlate that my address with my credit card account with my social security number, right? It's really hard to prove that hackers actually do something with the stolen data. So unless you can actually show tangible damage to Damien Real, you can't do anything about it. I can't be a plaintiff. Supreme Court of the United States said, well, that's not exactly right. You can have an injury that is intangible, right, that you can't actually touch or point to, but can still be a concrete injury. So that opens the way potentially for class action lawsuits to be able to go forward against companies that are lax in their security. This guy's been getting a lot of press for many years related to his work with this agency. In this last year in May, they produced 166 articles, which are a fun read if you want to do it. The Intercept is the website that does it. This is an Ars Technica piece talking about it. But internally, the NSA apparently thought that Iraq was totally worth all the effort. This is from 2005. Of course, shortly after 2005, that turned out not to be that true. There's a lot of citizen suits against the NSA based on the Snowden revelations. The materials, if you're interested, they go back and forth, but largely they're favoring the government and not the people that are being spied upon. Franken has done a lot of, there's been a lot of FISA hearings. The FISA court is the one that oversees the NSA to be able to say, the FISA court, yes, you can spy on this domestic US citizen, or no, you cannot. So there's been lots of talk about FISA. And Franken has questioned the head of the agency that relates to FISA, saying how many people have actually been eavesdropped, and they declined to respond. So there's no idea as to how many, whether it's a dozen or 1 million or 10 million or 200 million of US citizens have been eavesdropped upon. We really don't know. So Franken said, you know, the public lacks, I'm sorry? Well, when did that happen? So the hearing was in 2016, and there was no response. And so, and this is the, you know, it's probably grandstanding, right? I mean, it's probably Franken trying to make a name for himself. But he's saying that, you know, the public doesn't even know how much it is. So how can we know if we're striking the right balance if we don't know how many people are being eavesdropped upon, whether it's 20 people or 20 million people or 200 million people? Privacy Shield, if anybody works with any healthcare companies or any other EU or worldwide, the EU is the data sharing privacy law that applies to using EU citizens' data in the US. So the Privacy Shield was something we've had for many years. And the Court of Justice in 2015 said that the safe harbor that we had under Privacy Shield was actually struck down. It was invalid. So we were trying to figure out, okay, we in the US were saying, okay, what's going to replace the safe harbor since that pact has gone away. And of course, the European Court of Justice was thinking a lot about Snowden and the NSA when they said that the safe harbor was insufficient, when they were thinking, well, it's insufficient because the NSA can look at everything, right, even if there is a safe harbor. So in February of last year, there was an agreement that was called the Privacy Shield. But and in 2016, Privacy Shield was ruled inadequate in July. They said, thumbs up, full speed ahead, let's go ahead. And then on July 12th, it became effective. And on August 1st, they began accepting applications. And then it was challenged in October of 2016. And just yesterday, the EU General Court said there's a vote of no confidence, saying that even the Privacy Shield is not necessarily going to cut it. So there's a big question as to what the US can do to be able to safeguard and comply with EU rights when it's holding EU citizens' data. It's still an open question. What's going to happen? Social media is always a hot topic. There's a Gmail, of course, everybody knows, scans electronically what the content of your email is and then gives you contextually relevant ads on the right-hand side. There's a lawsuit saying that that's wiretapping, that they're essentially eavesdropping, and they shouldn't be doing that. And that's going through. It turns out Google said this should be dismissed, and the court said, no, 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 there might be something there. So the case is going forward. Similar things happening with Facebook, private messaging. They scan it. There's a class certification, and that's cases going forward. It has not been dismissed either. Everybody hear about the Zuck and his passwords? So it turns out that his Twitter and Pinterest passwords are da. Seriously, da. And so it turns out that, yeah, even he can have horrible passwords. So everyone's seen this, right? I'm not sure. How many people think that that is pronounced owned? And how many think that it's pronounced pwned? So owned, pwned? All right, good. So it turns out that, at least the sources I had, they thought it was owned. So I'm glad it's pwned is the word. So it turns out that Texas A&M, if you're going to be driving around, it's a good thing to go ahead and be topless and then take a Snapchat selfie and then run into another car. And thankfully nobody was hurt, but apparently there was drinking involved. It's going to surprise everyone here. Copyright, trademark, trade secret. There's a huge case regarding APIs with Oracle and Google. And the content, of course, was Java, the Java APIs, which Google integrated into Android. In 2012, there's a copyright trial saying that Google's use of the Java APIs in Android was a copyright infringement. And the jury deadlocked. They couldn't decide whether that was fair use of the copyright or was not fair use and infringing. So the court said, oh. So in May of 2012, they went forward with a patent trial, saying that Google's using the Java APIs was a patent infringement. And then in May 2012, the court said, nope, it was not patent infringement. So now, fast forward to May 2016, there's copyright trial number 2, because remember copyright trial number 1, they said, oh. So then they said, okay, Oracle said $9 billion of damages for these 37 APIs and 11,000 lines of code. The jury said, yep, it was fair use. They were totally fine. Google was totally fine using the Java code in that case. So in that case, Google won, Oracle did not, which doesn't make me sad in the least. Unless Oracle hires me, and then that would make me totally sad. If you're watching that in your yacht, Mr. CEO, let me know. The Asian band is called the Slants. I'd never heard of the Slants, but apparently they wanted to trademark their name. But the US Patent and Trademark Office said, no, 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 you can't trademark your name because that's offensive, even though all of the people in the band are Asian. You know, they're using something that is offensive. You know, that's there's some sensitive areas there. But the Trademark Office said, no, you can't do it. And the Federal Circuit, reviewing the US Patent and Trademark Office, said that you can't ban somebody just because you think that it's offensive. They said that banning is a violation of the First Amendment. It's unconstitutional. You can't refuse to register those disparaged marks because they disapprove the expressive messages within there. So query whether that's going to go up to the Supreme Court. And it turned out that it's being considered right now. So essentially, they're saying government can't disapprove of private speech. So it was just argued before the US Supreme Court this past January, a few months ago, and we will have a decision anytime soon. Similar arguments with the Washington Redskins, right? The idea of they canceled those federal trademarks, and they said, oh yeah, just like the Slants. And so, so query whether we're going to be able to, that's currently pending in a lower circuit court. Of course, we're all sad about Prince leaving, but he did leave in his wake a really silly lawsuit, which was suing a mother. Has everybody seen this video, or has anybody seen this video? I don't have time to play it, but essentially the kid was dancing to Let's Go Crazy. Prince, at least his company, sued the mom for copyright infringement, even because it was playing in the background. The Ninth Circuit, which is the Ninth Circuit Court of Appeals, which people have heard a lot about lately, but they said, no, that's the copyright holder has to show that is not fair use, right? If a copyright holder ignores or neglects that you have to consider fair use before issuing a takedown notice. Because generally the way these things work, right, is Prince sends a takedown notice to YouTube, YouTube takes it down, and then if YouTube thinks that it is fair use, then they put it back up. So what the Ninth Circuit is saying is before Prince even sends that takedown notice, they have to say, okay, is this fair use or not fair use? And if they have a reasonable suspicion that it is fair use, or if they should have a reasonable suspicion that it is fair use, you can't send the takedown notice in the first place. That's what the Ninth Circuit said. The DMCA safe harbor is that same process where the YouTube is considered a safe harbor that because this process is in place, they will not be held liable for copyright infringement, right? So if this really was copyright infringement, if the copyright holder sends them something and they pull it down, they can't sue YouTube later on. That's the DMCA safe harbor. YouTube has a safe harbor that they can't be sued for copyright infringement. That's going to be changed, so if anyone here works in the content industry, you'll want to listen to this. In the past, you just registered an agent for takedown notices, and then you registered once, and then it's never going to happen. You don't have to do it again. Under these proposed changes that happened last year, and it'll still be considered, you have to renew that every 3 years. And if you don't renew it every 3 years, you don't renew your agent, then you lose that safe harbor. And then you might be able to be sued for copyright infringement that your users uploaded content to, even if you didn't do it yourself. So that's a big change that is essentially a stealth liability, where it used to be you could do it once and forevermore you would be safe, but not forevermore. And even those who have done it, say in 2003 when they initially registered, they'll continue to have to re-register. There's no grandfathering going forward. So that's a big deal for anyone who has a website where user-generated content is a big part of their work. Redigi was a company that took Apple Music. So if you were listening to an iTunes song and you thought, I don't listen to it anymore. I want to sell my iTunes song, my digital song, to someone else. How can I do it? Redigi said, hey, let's create a marketplace. So what happened was that you could sell it to Redigi. Redigi would give it to somebody else, and that's essentially you would be selling your digital goods. Court said, no, that's not right. These aren't tangible goods, so you can't actually sell them. And then the company stipulated a $3.5 million judgment, filed for bankruptcy. But now they're appealing to say, hey, maybe I can take this digital thing and sell it in a secondary market. So can I sell my Kindle book? I don't know, maybe, maybe not. I know I can sell my physical book, but when I give my book to somebody else, then I can't use it anymore. But if I sell my Kindle book, maybe I can hold on to it and give it to somebody else. There's all sorts of tricky things. But the biggest rule to be coming from this case is that who cares, right? People are still buying music, right? Who buys music anymore? So this is a case where the law is still trying to catch up with yesterday's problems when largely the marketplace has gone on to stream instead of buy. Because streaming, of course, I don't own the things that are being streamed to me, where I might own something that I buy. I might own a book or a CD, or maybe I don't. Defend Trade Secret Act, we in the past have had a patchwork of state laws that relate to trade secrets. Now the feds have created an overarching umbrella law that will essentially fill all the holes for all the other states that didn't. Essentially that you can take property based on this, you can have federal jurisdiction, and largely doesn't preempt state laws, but it essentially fills in the gaps around them. Trade secrets, the EU is also getting into the game, where they are saying that in May 2016 they passed a law about media investigations, employee mobility, whistleblowers, damages. You can get all sorts of good things if you're in the EU and have trade secrets that have been breached. Anybody who does data mining might be interested in this case. This is a case where a company went through, and textual data mining is pretty common, right? You scoop up everything on the interwebs and then put it in a database and go from there. What these people did is actually scooped up all the video. So they took all the video, they digitized it using voice recognition and all sorts of things. They transcribed the content, and then they were able to figure out almost in real time what people were talking about on the news shows about this particular area or that particular area. And then the US Army and other government organizations would pay this company money to say, okay, are we generally being talked about favorably with this government program or this military action? Is that being, are the news programs talking about it favorably or unfavorably? How's the public sentiment? So they essentially, Fox News said, hey, you can't scoop up our content and resell it this way. That's not fair. And so the Southern District of New York said, no, it looks like you can actually do that. That's fair use, because Fox News was providing this content to the world for one purpose. And then this other company was actually using it for a totally different purpose, right? They're using it for data analytics rather than entertainment. So it's A-OK. It's fine. What wasn't fair use about it is the actually downloading and archiving of it later on. They said that was not fair use. So there's some nuance as to whether that's permissible or not. Now they've been appealed to the Second Circuit. That's being considered now. There's an anti-circumvention provision of the DMCA, which means that if you put it, if a content provider puts DRM on something, the digital rights management, you are not allowed to break that DRM except for certain exceptions. And so the Copyright Office last year created some other exceptions saying, for motion pictures, you can do it if you're blind or deaf. You can put subtitles or other things on there. And there's all sorts of other exceptions. And the EFF, the Electronic Freedom Foundation, is actually challenging that anti-circumvention provision altogether, saying there's no reason why I can't break a digital lock for whatever reason I want, right? Even if it's just me wanting to play with things, right? I shouldn't be held federally accountable for wanting to play with things. So they're suing. We'll see whether that has any legs. IoT is a big deal. There's the first IoT-enabled contract, which as a legal tech nerd, that makes my heart a pitter-patter. They essentially put all, I don't know much about commodities, but it turns out that if you're shipping grain, bales of cotton from Texas to China, how hot it is in the containers, how much moisture is in the containers, and all sorts of other data points really make a difference as to when it ultimately gets there, how much that thing's worth, right? So it actually may change in value a bunch of times between Texas and China. So what this contract does is actually monitors in real time all of the temperature, humidity, et cetera. And then the value of, you can see the value of the thing in the truck or in whatever the container is in real time, whether it's going up or down based on those volatile things. And then the contract is built to be able to say, whatever the sensors say, that's what the final price paid when the thing gets to China will be. So this is a way that just blows my mind that we can be thinking that way. And you might imagine other applications of IoT-enabled contracts going forward, smart contracts. Heart procedure, this is really fun. Maybe not fun for the guy on the surgery, but so he was having this heart procedure, and then a virus scan started going. And they had to reboot the machine while this guy was laying on this heart. So it's horrible, right? But it shows that you need to know your tech if you're a healthcare provider, because certainly the blue screen of death, they could have literal translations. Child privacy, that's always been something I bought a camera for my kid because I have currently an audio thing where I can hear if the kid is screaming or not. But I thought, I want to see if the kid is running around, because they may not be making noise, but they may be up to no good. But it turns out that maybe that's not a great idea. There's a real big question as to listening devices and whether that invades privacy or not. Alexa and Google Home and these others wait for wake words, right? Hey Alexa, or OK Google. Query how much beyond those wake words they're actually collecting, and that's been a big question as to whether they satisfy COPPA, which is a federal law that you can't collect information about kids under age 13, right? If your kids are saying things to Alexa or Google Home, how much is that violating COPPA? And especially when you have a case like this. People have heard about the murder, Alexa as a murder witness, Bentonville, Arkansas. A bunch of guys are sitting around drinking, sitting in a hot tub, like guys do. And then apparently the guy goes to bed, and the next morning the guy was face down in the hot tub dead. And the cops are saying, hey, we want to figure out, there was an Alexa involved, at least there was Alexa in the house. Amazon, go ahead and give us all the data, because we want to hear at what time people were asking, hey, Alexa, play this song, right? Or this kind of thing, to see when this person died and what the circumstances were. And Alexa's saying, we're not going to give you that, right? That's a Fourth Amendment. Under the Fourth Amendment, that's unlawful search and seizure. Go ahead and get a warrant and then come back to us. So there's some back and forth as to whether Alexa will give up the data from Alexa. Because of course the Alexa itself, the device itself doesn't have the data, but it's all up here. And of course the up here is all controlled by Amazon. And you can imagine that's going to be a fight now and later. Talked about my sleeping kid. This is one of the reasons I don't use it anymore. Is, it turns out Shodan, people have heard of Shodan. Turns out that you can, they have a search engine for all sorts of crazy things, including sleeping kids. You can go to this website and go real-time feeds of sleeping kids. This is an example of one of them. I don't know who they are, so I'm not violating anybody's privacy by showing this to you. But yeah, they're open ports, no passwords, and so it shows that all these companies, these IoT companies, are shipping things off to market with security as an afterthought, if a thought at all. And the query whether security by design really needs to be a part of our IoT world. FTC has thought about the IoT. They had a big session, and I know the author of this Internet of Things report. But essentially, they said, it's too soon to really figure out what kind of regulations we can do because the tech is going so fast, and something we regulate today might be meaningless, right? It might be us regulating whether you can sell digital music when it doesn't matter anymore. So essentially, they're doing hands-off with the FTC at this point. Fitbit was sued over their sleep tracking technology. Essentially, people with sleep apnea and other sleep disorders were saying, hey, you Fitbit, we're saying this could do all sorts of great things for my sleep. And it turns out doctors didn't really support that. So I'm going to sue you in a class action saying that this is not a medical device like you're saying it's a medical device. And Fitbit tried to get it kicked, and the court said, no, there might be something here. So it was not, didn't let the Fitbit kick it. Turns out that, I talked about self-driving cars, query whether that's Internet of Things or some other thing, but Tesla, it turns out if you find a bug in Tesla code, they can give you a bounty for such things. So if you are inclined to do such thing, go to Tesla and don't go to GM, which they'll say, oh yeah, we won't pay you, but we won't sue you for breaking in, finding a bug in our thing. So between the two, I think it's clear which one you want to bug bounty for. A flying drone that shoots flames, shoots guns and flames. Have you guys heard about this? It's so awesome. Awesomely terrifying, but if I had more time, I'd show you the video. But it's a drone, a quadcopter, that they essentially had a 9mm gun that was shooting in this, I think it's in Connecticut, yeah, was shooting this 9mm gun, and then later he had a flamethrower, you can see in the bottom, where they said, this is me roasting a turkey, right? And then it just eviscerates this one. The FAA turns out doesn't like that too much because that's a flying thing that is, maybe under their purview, right? This is in aviation. But the parents of the kid said, no, this is, it's in the air, yeah, but it's in the air like a Frisbee, right? Or it's in the air like a paper airplane, right? You don't have control over, it's not like a real plane, right? It's just a quadcopter. So there's a question as whether a flying death machine can be controlled by the FAA or not. Patents are always a big deal. I've got 10 minutes left, so I'm going to fly through. Honeywell, hometown company, made something like the Nest. They've been fighting for years. They decided to do a détente and do a cross-licensing agreement. Fitbit patents are invalid. Turns out the court said that even though they were granted the patents, they would go away. Internet of Things, net neutrality. That's how, I'm sure almost all of you know what net neutrality is. 2014, the DC Circuit struck down the rules, saying that you should go ahead and make new rules to see whether it's a common carrier or not. And this net neutrality is seeking to avoid things like this, where the Netflix speed went down until Netflix agreed with Comcast to a new deal, and then all of a sudden the speed goes up. So the question is whether you need to pay to play for fast internet speeds, or whether all bits should be created equal, regardless of whether you pay money or not. So in March of 2015, the FCC said you're a utility. So because you're a utility, there's all sorts of restrictions as far as whether you need to pay to play or whether you can do all these things, throttle, block, paid prioritization. And in June of last year, the DC Circuit affirmed the FCC. Said, yep, the FCC was right to be able to call them a utility full speed ahead. So there's a collective sigh of relief that I was like, thank God. Net neutrality, which was the way of the world forever, and the ISPs were looking to change to the detriment of everybody except for the ISPs. Thank God net neutrality is saved. But did you guys hear that in November something weird happened? And so now there's a big question again. So the FCC chair, Tom Wheeler, under Obama, the FCC has three people, right? Two are with the president party and one is with the non-president party. So Tom Wheeler was the appointee under Obama, and now Ajit Pai is the new FCC chair. Tom Wheeler's out of the picture. And so he has forever been opposed to net neutrality, especially opposed to calling it a utility, as the FCC had ruled before. So query whether we're going to have net neutrality safety or not. Interestingly, Ajit Pai is a former Verizon lawyer. So he was a lawyer for Verizon before he became the FCC chair. Another thing to talk to your congresspeople, if you care about net neutrality, it's on shaky ground at this point. It might go away. EU, on the other hand, if you want to move to the EU, which some of you might be thinking about, they said the initial rules had a bunch of loopholes that Lawrence Lessig and Tim Berners-Lee said this is ridiculous, so you need to close up the loopholes. The EU did. The zero rating, this is where T-Mobile says, you know, you can stream all the Pandora or Spotify or Google Play Music you want, and it's not going to count against you for data usage, which generally as a consumer you think is awesome, right? I don't want to pay for data usage. I want to eat all I want. The problem, at least with some people, are arguing, well, that's fine for you, but that might set up a really bad precedent because then they might say, they might charge Pandora, Spotify, these other ones. T-Mobile might charge them extra to give them that preferential treatment, and that violates arguably net neutrality. So the FCC last year had said that you can't have, they were investigating this zero rating scheme, saying that maybe it's illegal. But then Ajit Pai said, yeah, we're not going to investigate that anymore. So that is now free and able. So good for you that you can stream all the music you want. Maybe not good for you that net neutrality is on shakier ground. Data throttling has been a big deal. The FTC thought it was wrong. This is not that as interesting as other things. Right to be forgotten. This Spanish lawyer said, hey, I want to be forgotten, so Google shouldn't be able to, searches for me shouldn't show up on Google. It had the Streisand effect showing, you know, now everybody knows who that guy is. Everybody knows what Barbra Streisand's house looks like. Turns out that there's a big precedent for trying to make people forget things that actually happened. What happened in the last year is that Google implemented this right to be forgotten, but saying that if you went to google.fr, it would be wiped. But if you went to google.com, it would not be wiped because, of course, the French can't say what we can do in the US, but they did. The French said, hey, you Google need to do the .com too because you know, it's too easy for somebody in France to go to the .com version and see all these things. And Google's like, hey, you're France and we're the US, and who are you to say what we can see or not see in the US? Because like would we listen to Kim Jong-il or if, in North Korea if he said that I needed to do something, right? You're a sovereign state, we're a sovereign state. You can't tell us what to do on our side. And they said, well, we can tell you that you're going to be fined of $1 and $2 billion a day if you don't do the thing, right? So that's the tricky thing. And there was a study showing that you can easily find the forgotten pages by doing a delta between what was there before and what was after. So it's really a ridiculous thing that the EU is trying to do. And Tokyo's getting in the act too. They talk about a right to be forgotten. This guy, it's a horrible person, apparently. He was into child prostitution and pornography. So he was asking that his conviction for that be forgotten. And thankfully, I guess the Japanese courts fell on the side of saying, no, this is too important of an idea that we can't just erase this criminal history that stays on. Municipal broadband, the FCC was trying to encourage such things. Some states have prohibited legally, saying you as a city are prohibited from having municipal broadband like you are like you currently offer water, right? You currently offer gas. People said, hey, I want to offer Wi-Fi. Some states prohibited the offering of Wi-Fi, largely to the benefit of the ISPs and the detriment of everyone else. The FCC sought to trump those state laws, saying you cannot prohibit some municipality, some city from offering Wi-Fi. But unfortunately, he lost in the Sixth Circuit, and now the FCC is not going to chase that anymore. ADA, if anybody builds websites, I assume maybe one or two people build websites here. There's a real question as to whether the Americans with Disability Act applies to websites or not. There's a case in the Ninth Circuit said that ADA only applies to physical locations, does not apply to websites. But there's also a District of Vermont case that says that Scribe does need to comply with the ADA. So there's, of course, differing opinions, and we might need a Supreme Court case to be able to settle whether you do or do not need to comply with the ADA when making websites. California court just last year said that a web retailer must comply with the ADA. That's a state court, which isn't necessarily covered by the Ninth Circuit, which covers the federal courts. So without getting too much into civil procedure, it's a mess and it's unclear. And the shining star that could actually alleviate some of that confusion, the DOJ says, yeah, we're not ready to say whether it's a violation or not, so we're just going to kick the can until 2018. If then, maybe later. Turns out that people will give away their firstborn child 74% of the time. Literally, they will click to get free Wi-Fi. They would give up their firstborn child. They agreed. Password sharing. There's a Ninth Circuit case saying that this person violated the CFAA, the Computer Fraud and Abuse Act, by sharing the password. And the minority said, hey, people share passwords on Netflix all the time. Doesn't seem cool. Installing malware didn't need a warrant, it turns out, according to the Eastern District of Virginia. Turns out that Panera and McDonald's people don't, Starbucks people don't like people surfing porn and their things, so they shut off arguably a First Amendment question. Turns out at NYC they had the kiosks, right? Same thing. Turns out people like watching porn, even on busy city streets. NIST did a pretty good thing saying that that two-factor authentication via text is not secure, so you shouldn't do it. So if you're implementing two-factor authentication through SMS, probably not a good idea. Firefox, there was a flaw that the government used to exploit in Tor. Firefox said, hey, tell us what the flaw is, because we want to fix it. And the government said, we want to keep using it. So the Firefox said to the court, hey, make them tell us what the flaw is. And the court said, yeah, tell them what the flaw is. And then the government said, yeah, you don't want to force us to do it. And then the court said, yeah, we don't want to force you to do it. Right? These aren't the droids you're looking for. So now Firefox didn't know what the flaw is. You can serve somebody by Twitter, according to this court. If you want to see some assets, go to 50 Cent's webpage, and he's going through bankruptcy, and he said he's broke, as you can see here. And then the court said, hey, you're not broke, because you just have a stack full of cash. You put this out on social media. 19-year-old Stanford kid decides that, hey, I want to make a chatbot for getting people out of parking tickets. And this is in the UK, his home in the UK. It turns out he's, I think it's $9 million worth of parking tickets that got appealed successfully using this kid's chatbot. So then he's extended the tech to be able to say, if you're homeless, here's an application for homeless benefits. And now he's more recently, with the refugee crisis, said if you're a refugee, this is how you can apply for different refugee status. Cool things. Lawyers are saying, well, gosh, the only thing worse than no legal advice is bad legal advice, right? What if this 19-year-old kid doesn't know the nuances of these legal implications? And what if this person gets denied refugee status because the chatbot didn't have an algorithmic answer for the thing that they actually need? AI can, it turns out, predict things. Turns out. And the AI is magic, right? So it's AI is whatever the user wants. All right. Last thing, drones, you got to be regulated. And turns out there's something going on with Russians. A court used emojis. And Facebook, this is the last one. This kid said, hey, parents, you posted all these embarrassing things before I was age 18. You need to get sued because that's a violation of my privacy. Still going through in Austria. Thank you so much. Oh, think about that, huh? 178 slides, pretty good.